appellant. Mr. Atkins, you may proceed.
Good morning, Your Honors. Wayne Atkins for the appellant. I will reserve 3 minutes for rebuttal.
Very good.
And this is a case that arises from an indirect contempt proceeding based on the failure to comply with a search warrant. We initially presented 3 issues in the initial brief. We ended up conceding one of the issues after reading the answer brief as to the jurisdiction of the court. So that now there's only 2 issues pending before the court. One is whether the underlying order that was compelling the disclosure of cell phone passcodes was void. And then the other issue is an issue of whether there was sufficient evidence of intent based on evidence of whether the order was translated for the appellant. So I'll start with the issue of the validity of the order. This is an issue that's been currently pending for the Supreme Court based on a conflict amongst the district courts. Oral argument was held before the Supreme Court in November. We don't have a decision yet. That obviously may impact what we do here today. Until then, I'll acknowledge we have to follow the Stahl decision from this district. However, I've offered a couple reasons in the brief as to why that might be a little factually distinct, which actually might help to bring some of the district courts a little more into harmony. So in Stahl, that case was a video voyeurism case where there was evidence that the defendant there was observed using the phone to conduct video voyeurism. So it was very targeted in that case. And then in the course of deciding that opinion, holding the compelled disclosure of the passcodes there was proper under Fifth Amendment, and whether it was a testimonial communication, it was the focus was on the knowledge of the passcodes themselves, because as part of this Fifth Amendment analysis, there's an exception to testimonial communications if it's a foregone conclusion that the state would sort of get that evidence, that they know the evidence is there, that the defendant is possession of it, that it's authentic, is I believe the 3-pronged standard. But it was a very targeted request there. And this court held that, well, there's evidence he knows the passcodes, and that's all we're concerned with, not the evidence they might ultimately get from the cell phone. But they actually included a footnote at the end that kind of acknowledged, like, yeah, this is very, even under the kind of a broader view of this doctrine, we think it's still safe. Since then, there have been other district courts that have focused more on the ultimate evidence to be uncovered. But if you look at the request,
Mr. Atkins, before you go to the other courts, let's address something in Stahl to this case, because we are bound to follow Stahl if indeed Stahl is applicable here. And so one of the things that Stahl says is to know whether providing the passcode implies testimony that is a foregone conclusion. The relevant question is whether the state has established that it knows with reasonable particularity that the passcode exists, is within the accused possession or control, and is authentic. And so if we were to apply that test to our case, aren't all of those elements met here? Because you have the accused's possession or control of the phone itself, and he was seen using the phone at the time that the detective saw him using the phone. And so, and I think it's also, as far as authenticity, basically the case discusses that, okay, once we punch the numbers in the code, punch the numbers in the phone, then obviously you know that it works if it unlocks the phone. So that would provide the authenticity element. So if you would answer that question.
yes, obviously we are bound by the decision in Stahl, but to answer that question, I mean, yes, there's evidence of sort of all those elements. I don't know that it's conclusive and all that I can conceive of, although it's not in the record, how you can talk on a cell phone. I think you can answer without a passcode, but that's not something that was really developed factually. So it's possible there's still wiggle room there factually, but yes, there's at least evidence in all those points. I mean, it could be subject to a little debate around the edges, but I think so. But sort of looking at the requests there, because Stahl had a very targeted request of seeing this phone being used in the course of a crime where the phone was used to conduct the crime itself there. So I think what the other districts got a little hung up on is it wasn't as directly tied to the crime. It's sort of, state was generally seeking communications, kind of like what they're doing here. And they were hung up on, by providing the passcode, you're sort of authenticating a whole broad range of documents and communications. And that's how they distinguished sort of surrendering a key to a house from providing a passcode to a wall safe, I think is what the case is.
Right, but by necessarily providing the passcode doesn't mean that the defendant here is admitting to all of the contents. I mean, that would be subject later to a motion to suppress, right?
I mean, they're admitting that they know the password that to the thing that has those contents. So in a sense, it's an admission of it. It's not, again, it's not like, I don't think it's a conclusive admission. Obviously that's subject to being further developed and challenged, but I think there is some admission where it is evidence of some knowledge of the contents of the phone, and it's authenticating sort of, I guess, the act of production. It's sort of authenticating a much broader category of things in the other cases than it is in, I think,
Stahl. Wasn't there, yes. But was it, I mean, and I know the caution is just to let the state go on a fishing expedition. But here you actually have some, I believe it's like AT&T records that they had some independent evidence of that would tie in the time periods in which the defendant here was on the phone, correct? With
yes, there are those records that do tie the phone to the defendant. So that's certainly evidence that the state presented and has. And yeah, I think the concern is sort of the fishing aspect, but it's a difference in Stahl. It's sort of like fishing with a line for a specific fish. In the other cases, it's sort of fishing with a net, casting a wide range of things, seeking more general communications as opposed to direct evidence of the crime that he knows on the phone. But obviously the Supreme Court's gonna weigh in and resolve this, hopefully soon, and that'll probably have a big impact on what we're doing today. Here, that argument wasn't really developed as much below. I think the state acknowledges in their answer brief that before the contempt proceedings, there wasn't really any opportunity to challenge it. And even at the hearing itself, the judge didn't really want to hear and get into evidence of whether the order itself was erroneous in any way. There's some objections to relevance that he sort of sustained on that ground. So this wasn't fully developed and fleshed out, and that itself's kind of limiting, I think, us a little factually. And as for the state also raises an argument that a motion to suppress is sort of an adequate remedy for this. I don't believe that to be the case, because it's sort of, well, a couple issues there. One, it's sort of the cat out of the bag issue we run into in the context of at least civil discovery requests and certiorari. And then also just the risk of being held in contempt of court is sort of itself almost recognized in some of those same cases as a form of irreparable harm. So it's hard to remedy an issue like this after the fact, even in the form of a motion to suppress. So that's kind of the issues I have as to the validity of the order itself. Unless there's other questions on that topic, I'll move on to the kind of second issue of the evidence of the intent. So the issue with intent is there's evidence in the record that this order, my client speaks Spanish. This order was translated by an officer who didn't testify into Spanish, but the officer who did testify didn't really speak Spanish, admitted he can't really confirm whether the order was read accurately. And sort of a fundamental element of a contempt violation is willfulness. I'm sorry, did someone speak? No, it's an issue of willfulness, and you can't be willfully in contempt if you don't know what you're being ordered to do. And so we think there's a failure in the elements there and a lack of competent substantial evidence on this point. I did cite to a couple cases, one from this court and then one from the 4th DCA that sort of recognized in the context of admitting translations that you don't need to necessarily have a certified translation, but there needs to be some safeguards to ensure there's accurate translations before they can be admitted into evidence. And I think that can be sort of applied by analogy here, where we just don't have competent substantial evidence that my client even understood what he was ordered to do at the time. And other than that,
And the cases on that point, I think you had Lopez and I think it was Mendez Martinez. Those cases there, a transcript was actually being admitted. Do you have any circumstances here, any cases where the officer who was testifying was not the one who did the translation?
I couldn't find anything like that myself. Yeah, I recognize those cases are both, they're not in the contempt context, but yeah, they're both trying to admit, I think, translations or transcripts, I believe, but I couldn't find anything quite like this, where it's an officer, a non-testifying officer is one who did the translation. But those cases, I do recognize some sort of safeguards to using these transcripts where there needs to be some evidence of whether they're even accurately translated that can be subject to cross-examination. And where we don't have that at all here, we're just operating on, I guess, the testifying officer's assumption that his colleagues translated accurately. And that's not enough, that's not competent substantial evidence of the element of intent. But no, I have nothing exactly in kind of the context you just described.
Okay, and you would concede that that issue wasn't raised in your response to the motion to compel, or I guess it was to the order to show cause?
In the response to the order to show cause, I'd have to double check. I can't remember. I don't think so. I know it was definitely raised at the hearing, but for the response to the order to show cause, I'd have to confirm that. It probably wasn't fully fleshed out if it was raised at all. I don't think it was, but I'm struggling to remember that particular document off the top of my head right now. I know it was developed at the hearing, but that's it.
Mr. Atkinson, let me ask you, to take this issue to a broader context, would anytime there is a discussion between an officer on the scene and someone who speaks another language, where the officer on the scene speaks in the base language for the defendant, that particular officer must always come in and testify that he accurately told the defendant whatever it is that's at issue, he or she?
No, not always. It's in this context, it's because we're in a contempt proceeding. So knowledge of the order itself is a fundamental element. So being
you have testimony, it was translated, and I understand what your argument is, but your client did not testify. No evidence was presented challenging the adequacy of the information provided to him, was there?
No, he did not testify.
And I understand you're saying, well, it's a shifting of the burden of proof, but again, to take it to what I think is the next logical step is, if a person makes a confession at the scene of a crime after giving Miranda warnings translated into the native language, then it seems like you're positing that there has to be some independent proof by someone at the trial or the suppression hearing that says the warnings were accurately, fully translated, and it appeared the defendant understood them, as opposed to a witness testifying. It seemed clear at the time that Officer A translated and the defendant responded appropriately to questions.
Understood. So it's very context specific there in the context of whether we're confirming the accuracy of Miranda warnings. That would, I guess, be raised in the context of a motion to suppress. And I think the burden's a little bit different there. But as for a confession itself, there's going to be probably, there's usually, I think, other evidence of a crime beyond the confession. But if you're relying on in a contempt proceeding, I think knowledge of the order itself and what it's required is kind of the central issue for the willfulness. And I think there, for the state's burden to prove willfulness in that context, it's a lot more problematic to rely on essentially the assumptions of the only witness who did testify, that he asked it to be translated, and but he doesn't know if it was translated accurately, and admitted he doesn't know. But I think those are a little bit different contexts than what we have here. An admission, yeah, obviously, if there's, I think in that point, if you're trying to suppress it, there might be a burden on the defendant to come forward and challenge and say it wasn't voluntary. But in the context of the state proving intent on a contempt charge, knowledge of the order, I think, yeah, there does need to be some evidence that it was accurately translated. But no, not for every conversation with the defendant ever, or a witness ever. I think it's very context specific.
Very good. And you still have your a little bit more than 3 minutes if you have anything further you want to add.
Understood. Thank you.
Very good. Thank you very much. And I'm having a little bit of computer problems today, so you all forgive me. Ms. Heim.
Good morning, Your Honors and Counsel. May it please the court. My name is Allison Heim. I represent the state of Florida. As an initial matter, the merits of the underlying search warrant are not actually properly before this court for consideration. And to the extent the state's answer brief states otherwise, state steps back from that position. And instead, the narrow issue before this court only deals with sufficiency of the evidence of the finding of contempt. So that leaves just essentially, there was an order directing the defendant to do something, and then the defendant's intentional refusal to comply. So in this case, I don't think it's disputed that the search warrant itself directed the defendant to supply a passcode. So we have the order directing the defendant to do something. So the real issue is if there was an intentional refusal to comply. So counsel discussed a lot about what happened at the evidentiary hearing on this matter and the Spanish translation. However, before the parties even stepped into that particular hearing, the evidence of intent was already proven beyond a reasonable doubt. And that was done so in the appellant's written response to the court's order to show cause. In that order, he did not challenge the Spanish translation or indicate that he didn't understand or even wanted an attorney, nothing like that. Instead, he indicated that he had every right to refuse. That's on record page 11. He had every right to refuse compliance because he believed he had a constitutional right to do so. Then again, on page 20, he admitted intentionally refusing to comply, where it says the appellant believed he could refuse to provide the passcode to the cell phones because of his Fifth Amendment right and his Fourth Amendment right to challenge the validity of the search. He intended to exercise his constitutional rights. That can be taken as proof of intent based on this court's holding in the Hope v. State case. And in that case, it was very similar to this one, where the defendant was called to testify before a grand jury. He refused to testify. The court initiated contempt proceedings. And during the proceedings, the state offered attorney argument showing the intent. The defendant on appeal argued that that was not sufficient evidence because it was simply attorney argument and they were not sworn to testify. But this court found that in the defendant's written response, he acknowledged his refusal to testify and said he did so because of his constitutional rights. So it wasn't a contemptuous intent to disobey. It was coming from more of a constitutional standpoint. And this court held that that written response was enough to show the evidence of intent, and that any further evidence during the hearing would have been superfluous and just in excess of what was already proven. So we have that same issue here. The issue of intent was proven before the parties even entered into the evidentiary hearing. As I stated earlier, I don't believe that the constitutional arguments and the merits of the underlying warrant are properly before the court. And even if an order is erroneous, unconstitutional even, a defendant still has a duty to comply with that order until the order is modified or vacated or reversed on direct appeal. But it can't be collaterally attacked on an appeal of finding of contempt. We know that from the Jamison v. State case that was cited in the state's brief. And that went pretty thoroughly through the issue of why a defendant can be found in contempt for refusing to comply with an order, even if it's unconstitutional. And that's to essentially protect the judiciary's ability to make judgments and direct its litigants to do anything. In this case, it was a search warrant, without being questioned as to the validity before the orders are carried out. In this case, the appellant could have moved to vacate the order, moved to quash it. There could have been a writ of prohibition, but none of that was done. And instead, it was simply used as a defense to contempt, which the Jamison case specifically goes through why that's improper. So in this case, it was purely a notice of appeal of a finding of contempt, and contempt deals not with the underlying order and its validity, but simply with, was there a court order and was it intentionally disobeyed? And that's exactly what we have here. If we were in a world where we were considering the constitutional merits of the search warrant, then Stahl would be directly on point. As Judge Smith pointed out, there's the existence of the passcode. We know the defendant possesses it, and it's a self-authenticating piece of technology. Stahl is directly on point, and this court would be bound to follow that as its own precedent. However, we're not even here contesting, or we're not here discussing the merits of the warrant itself. It simply is sufficiency of the evidence of a finding of contempt, and the state has sufficiently proven that. So if there are no questions, the state would ask this court to affirm.
Very good. Mr. Hunt or Mr. Atkins?
Thank you, Your Honor. To close out real quick without kind of rehashing anything we covered. Yes, and as a general principle, you can't, it's not a defense to contempt to say an order is erroneous, but there's case law recognizing that orders of certain errors of a certain magnitude can be challenged that way. And I believe constitutional issues like this are of that magnitude. And I know in the context of certiorari and civil discovery, there's a case recognizing that, you can challenge those. Certiorari needs to be available because you can challenge, the only other way to challenge certain discovery orders at least would be through an order of contempt. So that almost implicitly recognizes there's still some room to challenge orders itself, the validity of orders itself through contempt. There's not a blanket prohibition against it like the trial court judge seemed to rule. But yes, it's somewhat limited, but I believe a constitutional issue like this would be of that magnitude. And other than that, I would only be rehashing anything I said previously, so we would ask that the court reverse.
Very good. Thank you both for the arguments. You can exit the virtual courtroom. And the next case on the docket is Springstead Holdings versus Del Prado Mall.